So here's a question. When do federal courts have the authority and the jurisdiction to step in and interfere with the proceedings and litigation that may be occurring at state court levels? We know, pursuant to the Supremacy Clause, that when there's a conflict between federal law and state law, that federal law controls. Right? We know that for sure. But what about court authority and court action? These are some really interesting questions that pertain to the way that our different levels of judicial oversight cooperate, collaborate, sometimes clash and conflict. These are important questions related to the stability of our system, right? So, welcome. This is the case law video overview for the Golden Gate National Senior Care LLC v. Beavens case. This is a federal district court case for the Eastern District of Pennsylvania from 2015. We're recording this in May of 2022. So this happened, roughly speaking, about 7 years ago in terms of the litigation. The actual events, as we'll talk about, happened back in 2013, so closer to 9 years ago. But this is a really interesting case that concerns a lot of elements related to, again, the authority of courts to sort of interfere with one another when justice requires, but also a lot of elements of arbitration and alternative dispute resolution discussed here, commitments to contracts and the agreements that we sign, and to whom those agreements pertain and to what extent, what causes of action are available and when, questions of jurisdiction, and a lot of really interesting elements here. So with that being said, let's go ahead and get into the case factual background. So the background of the case is fairly straightforward. Factually speaking, we have Agnew Beavens, who was a senior gentleman admitted to the Golden Living Center in April of 2013. So this is 2 years prior to the litigation. And he remained there until his death in September of the same year, right? So this all happened in the course of just a few months, really, when you look at the time scale, not even 6 months, 5 months' time. Now, upon entry to the facility, Agnew's daughter, Pamela Beavens, acting under power of attorney for Agnew, signed an agreement with the facility on Agnew's behalf, stating that any dispute rising out of Agnew's stay at the facility, and then there's some specific language here related to this, shall be resolved exclusively by an ADR process that shall include mediation, and where mediation is not successful, binding arbitration. So this is an ADR clause that requires first mediation, a voluntary process by where the parties will submit to a sort of a negotiator of sorts. A mediator is a professional individual assigned to hear the arguments from both sides and try to encourage meetings of the minds, cooperation, collaboration, and even reconciliation for the sake of reaching a peaceful settlement to whatever dispute is before them. In the event that the mediation is not successful, because of course, if the parties don't ultimately agree at the end of mediation, and this clause also says that the parties agree to subject themselves to binding arbitration, right? It's important, this word binding here, because an arbitration procedure with a binding conclusion has the force and effect of a legal conclusion in a court of law, right? As if you had gone through a trial process with either a judge or a jury or both. And this is ultimately the background for the again, the case here before us related to what's happening here. So the language that is being used or was used in this arbitration clause will be the subject matter of some discussion as we get further into the case. Now, the agreement itself covered a number of different subject matters, and this is important too, the scope of the agreement. It covered all disputes arising out of or in any way relating to the stay at the facility. The clause specifically included negligence, gross negligence, malpractice, and any departure from healthcare rule or standard. right? So this is a relatively broad scope of coverage. Negligence is ordinary lack of care. Gross negligence is generally considered an extreme lack of care. But this is speaking directly to the scope. Now, the important thing about what we're seeing here, and the important thing to note about what happened factually, is that Pamela, in signing this document from the Golden Gate Living Center in April of 2013, was signing pursuant to her power of attorney over her father, Agnew, right? So she was signing on his behalf for him and not in her personal capacity in any way, shape, or form. She was not signing as Pamela Beavens. She was signing as the person with the right to act on behalf with the legal agency for Agnew Beavens, right? And this will become relevant and important as we get later on into the case and the legal analysis before the federal court here. And Pamela had alleged that her father had been subjected to negligence in his care and treatment during his stay. She sued in Pennsylvania state court in Pennsylvania based on wrongful death and survival causes of action. So wrongful death is obviously a cause related to someone who, it's a civil clause related to someone who dies unintentionally, right? So this is, otherwise we'd have a criminal proceeding for something like murder or manslaughter. But nonetheless, we have something that, is alleged that the death was avoidable and was wrongful given the, the negligent action or careless action or neglectful action of some other party. The survival causes of action are actually brought on behalf of the individual who died. These survival statutes pertain to the kinds of causes of action that a person could have pursued if they had survived the incident in question, right? Things like loss of economic value, loss of wages, loss of quality of life, those kinds of things that an individual could have brought before a court if they had not died as a result of the incident action. And a survival statute allows the estate of that individual, right? The people that survive that individual that are their next of kin, to bring a cause of action on their behalf, which we call a survival cause of action. And basically that just says, hey, we're suing on behalf of this person who died for the things they should have been entitled to and would have been able to sue for if they had survived what happened here. Right. So that's really all that is in question. Okay, so now we have the ADR agreement and the analysis pursuant thereto. So this is again more of the discussion related to the specifics of the agreement. So on that subject, the parties agreed to submit their disputes to what's called the Judicial Arbitration and Mediation Services, also known as JAMS, JAMS, a New York-based mediation service. It's actually, incidentally, a very popular service in the ADR world, very well known, right? So the ADR agreement on the front page of the JAMS intake form, pursuant to the arbitration clause, stated, and this is important, so I'm going to read this aloud just to understand the scope of this agreement. The parties understand, parties in this case being the Golden Gate Living Center and Agnew Beavens, right? And the reason I say Agnew and not Pamela is that, yes, Pamela signed the agreement, but once again, she signed it on behalf of Agnew. So she was agreeing on his behalf to these terms. So the parties understand, acknowledge, and agree that they are selecting a method of resolving disputes without resorting to lawsuits or the courts, and that by entering into this agreement, they are giving up their constitutional right to have their disputes decided in a court of law by a judge or jury. Right. So this is a forfeiture of those rights to the normal litigation proceedings, that they are selecting that method without resolving to those normal lawsuits. Right. So this is the language of that clause. It also said that the signatories should get legal counsel and that they had 30 days to revoke the agreement. Right. So this is important, as again, we'll get to the legal analysis as it relates to claims of things like unconscionability. So important stipulations in the agreement said, number one, get an attorney, right, and advise both parties. If you don't have legal counsel, if you're not being represented by legal counsel, get legal counsel. Find someone who can review this for you and give you competent advice, independent of us being JAMS. Right. And that you have 30 days to revoke the agreement. Right. So if you sign it and you're not happy with it, Even if you don't have legal counsel at the moment, you have a month to go get some legal counsel, talk to an attorney, talk to somebody who knows about this. And if you're not comfortable with what you've committed to in terms of this agreement, you can back out within 30 days. All right. So these are all terms and circumstances that, again, will become important as we move forward. Nevertheless, Beavens refused to dismiss her lawsuit, right? So again, Beavens filed in state court, right, to sue the Golden Gate Living Center for the wrongful death and the survival actions, right, the causes of action on behalf of Agnew. And so she refused to dismiss her lawsuit. So then what happens? Golden Gate files a petition in federal court. Right. So same jurisdiction in terms of geographical coverage, but this is a federal court petition, not a state court petition. And Golden Gate is filing under the Federal Arbitration Act, right? So federal law, seeking a judgment that the ADR agreement applies to the parties' dispute and thus to compel arbitration. So basically, Golden Gate is going to the federal court, the trial court level, and saying, look, we have a state court action here, but the Federal Arbitration Act, which is a federal law, would require that the ADR agreement that Ms. Beavens signed on behalf of Agnew Beavens should be upheld, should be enforced, and it should compel her to have to bring these actions in arbitration and not in a lawsuit. They're essentially asking the federal court to stop the state court suit, right? Because of the fact that it violates the arbitration agreement that Ms. Beavens signed on behalf of Agnew. So Golden Gate also moved to stay the state court action, which was then in the discovery phase, right? So it hadn't gone to trial just yet. The discovery phase can last months or even years, depending on the scope and the scheduling order. But at that point in time, it was in discovery, and they were asking again that the federal court stay the state court action, basically issue an injunction telling the state court that they must stop the legal proceeding on that lawsuit, which is a serious move, right? So this is what is before the court. So Beavens moved to dismiss the petition to compel arbitration based on arguments that, among other things, federal court has no jurisdiction, federal court should abstain from getting involved in the state court proceeding, and the Anti-Injunction Act prevents this court from interfering in the state court proceeding. So these are the arguments, the counter arguments to Golden Gate, where Beavens is saying, we are moving to dismiss this petition and we are asking the federal court to mind its own business and stay out of this proceeding, right? For a number of reasons, which are these three: no jurisdiction, abstention, and that a specific legislative act at the federal level, the Anti-Injunction Act, would prevent this court from interfering. So we're going to take a look at how that shakes out now. So Beavens' motion to dismiss and the analysis that the court goes through to consider each of the three claims, right? The first is a lack of jurisdiction. So the Federal Arbitration Act itself, even though it is a federal law, does not bestow federal jurisdiction. Right? This is interesting because, as you may remember from early fundamental law classes or law curriculum, there's two ways to get into federal court, right? One is a federal question, and that would regard a question of law that is held at the federal level. The other is diversity jurisdiction, right, which is where you have complete diversity in the parties, which means that not one plaintiff can be found in the same jurisdiction as any one defendant, such that there would be a convenient venue at a state level rather than a federal level. So you need that first. You need complete diversity, and you also need at least $75,000 in damages and contention. That may sound like a lot of money, but it's really not when it comes to litigation, especially when you consider fees and costs and all the things that go with it. And whenever you're dealing with wrongful death, your claims are usually fairly high, right? Because the cost of a life is considered obviously to be extremely valuable and of the utmost importance. And so it's not at all uncommon when you have a wrongful death action that your requested damages, your demands will well exceed that $75,000 threshold. But what the court says here is that, look, the Golden Gate Living Center is asking us to enforce an arbitration clause pursuant to the Federal Arbitration Act. But the question before them is not about a question of federal law and its applicability, right? It's not saying, does the Federal Arbitration Act apply here? Because it certainly applies. It absolutely does. They're just asking the court to take the Federal Arbitration Act and leverage it on the state courts to stop the state court action. Therefore, we don't really have a federal question here, right? We have a request for enforcement of a federal law, and that's different. So we don't have federal question jurisdiction, which leads us only with the alternative of diversity jurisdiction. So the parties need an independent basis to be in federal court in the first place for the federal court to be allowed to enforce the FAA provision. So Golden Gate claimed there's jurisdiction because there's diversity of citizenship. And so this is the other way you can get into federal court, right? So Golden Gate obviously wants jurisdiction to be valid here. So they're arguing for it. And they're saying, all right, we don't need federal question. Forget that argument. There is jurisdiction because there's diversity of citizenship. And this, of course, gets complicated because most things in the law tend to be. So Beavens is a citizen of Pennsylvania. Golden Gate is a citizen of Delaware in California, right? So we have Golden Gate, which could potentially be sued in those two jurisdictions in a state court, but doesn't have the necessary ties to Pennsylvania. So it would appear we have diversity because we have the plaintiff that is a citizen only of Pennsylvania and is not matched with the defendant in any way. However, right, this is not where it ends. We have other defendants that have been added to this case, right? Individuals associated with the lawsuit, individuals who worked at the Golden Gate and had affiliation with the care in question that was alleged to have been negligent that led to the wrongful death and so on and so forth. And they were named as defendants in the action. For the purposes of our lawsuit, their names here are Francis Dunyan and Denise Curry. And Beavens sued both of them in the Pennsylvania state court. Both defendants in the state lawsuit, but they were not joined in the federal petition, right? And you could imagine why Golden Gate didn't do this. They probably didn't do it on purpose, right? Because it would defeat any argument they would have for diversity jurisdiction, right? It would basically undermine that because Francis Dunyan and Denise Curry would potentially be a means of establishing a convenient forum. So if they are quote unquote necessary parties to the action, then they should have been joined, right? But this would defeat diversity of citizenship since they are from Pennsylvania, right? So you would have that necessary tie where at least one plaintiff, in this case Beavens, shares a common jurisdiction with at least one defendant. In this case, you would have two defendants, right? Diversity of citizenship requires complete diversity between the parties, meaning not any one defendant and not any one plaintiff share any common jurisdiction. You can't find one commonality across the parties of any kind. Here you would have it if Dunyan and Curry are considered necessary. If they're not necessary, then them not being joined in the federal petition is irrelevant, right? And you would still have a valid diversity jurisdiction here. So the necessary parties, as we come to analyze what does that mean and how do we decide if they are in fact necessary. So the key question comes to whether Dunyan and Curry are in fact necessary to the petition to compel ADR. A necessary party is a party who is so situated that the disposition of the action in the person's absence may leave any of the persons already parties subject to a substantial risk of incurring double, multiple, or otherwise inconsistent obligations. In other words, if we left them out, would it be unconscionably unfair in such a way that it just wouldn't work, right? That we couldn't justify that decision. Must they really be here, right? That is the key question before us. So the court agreed that by definition, Dunyan and Curry are necessary parties, right, insofar as this relates. So the court grants the petition to compel arbitration in the action against Golden Gate, but not against Dunyan and Curry. Then Beavens would be forced to use ADR in her action against Golden Gate, but still sue Dunyan and Curry in state court, right? So this would be incongruous and inefficient, right? So as we're talking about this, they're saying, well, if we agree and pursue with Golden Gate's claims for staying the state action and forcing Beavens to go to arbitration with them, and then if she still wants to try to recover from Dunyan and Curry, she has to sue them separately anyway, right? And the court is acknowledging that this is kind of redundant and it doesn't make a lot of sense in terms of efficiency because we'd have parallel actions, right, which we're about to talk about, which is essentially the same thing being litigated in two different forms, right? One would be the Pennsylvania state court against Dunyan and Curry, and the other would be the arbitration proceeding through JAMS with Beavens against Golden Gate, right? So deciding whether to dismiss the case because necessary parties cannot be joined is based on a number of factors. And this is, again, we're getting deeper into the analysis. whether a judgment rendered in the person's absence would be prejudicial, right? And so again, this is a decision moving forward to the issue of jurisdiction and diversity, and deciding whether this is appropriate to make this move or not, in light of the fact that Dunyan and Curry are out of the equation, right? For if we could move forward without them in court, the extent to which any such prejudice can be lessened or avoided, right? Whether a judgment rendered in the person's absence will be adequate, whether the plaintiff will have an adequate remedy if the action is dismissed. And so the court said that the potential prejudice is insufficient to dismiss the case, right? So this is important to note. The first element, whether a judgment rendered in the person's absence would be prejudicial. And here, in terms of the person's absence, we're talking about Dunyan and Curry, right? Would that be prejudicial to the parties? The mere fact that Ms. Beavens may be faced with inconsistent procedural remedies is not enough to find that Dunyan and Curry are indispensable parties. Right, so now we're back to the question of whether they are really indispensable, or whether or not we can do away with them for this action, such that if they're not joined, then we have diversity, right? Then we get there. That's what we need. So the court is saying that the only real outcome, the only real hardship for Ms. Beavens, if they're not joined in terms of prejudice, was that she would have to do this sort of twice, right? She would have to take separate action against Dunyan and Curry in state court if she wants to, and then submit to arbitration with Jams against Golden Gate, right? So it would be a longer road to recovery, but that's about it. And the court is saying that's not enough to throw this claim out entirely, right? So in fact, the Federal Arbitration Act, as we're talking about, dealing with the enforcement from the federal level, it actually favors piecemeal resolution when necessary to give effect to an arbitration agreement, right? So the legislation here, the act specifically says, look, if you need to separate the parties and the claims for the purposes of piecemeal litigation, lawsuit here, a lawsuit in that court, or arbitration in this court, to honor the terms of an arbitration agreement, then so be it, right? So there's specific direction from the legislation on this issue. The FAA's strong policy in favor of arbitration overcomes any prejudice Beavens may experience from that piecemeal litigation that results from Dunyan and Curry's absence, right? So they're basically saying, because the FAA specifically says that this is promoted, right? Not just okay, but that we would prefer you do this, right? And this is coming from Congress and passing the act. That overcomes any argument from Beavens that says, hey, this is an inconvenience for me because now I have to sue Dunyan and Curry in state court and go to arbitration against Golden Gate at Jams, right? And so based on that finding, since there's no real prejudice here, there's no need to even go into the other factors, right? We don't have the other elements. We don't have to analyze each one independently because we don't even have the prejudice element, right? So this alleviates all of that, and we can find for diversity jurisdiction here, which would be sufficient for the federal court to find its own jurisdiction to hear this case. So that's the first, again, if you remember, of the three arguments coming from Beavens that says, here's why the federal court should stay out of it. The first one was jurisdiction, and that has fallen flat on its face. Now, the second is abstention, and the third is the Anti-Injunction Act. So we're going to get to these. So Colorado River Doctrine is the abstention doctrine, allows a court, right? This is important language, to abstain from exercising jurisdiction when a parallel ongoing proceeding is pending in state court. This is not the kind of parallel proceedings that we sometimes talk about and that we've talked about in past cases, where you have, for example, a criminal trial and a civil proceeding involving the same general factual events and incidents and parties taking place. This is parallel proceedings of the same civil nature, one happening, say, at the federal level and one happening in state court. Then what to do, right? And when should the federal courts abstain, right? So the Colorado River Doctrine, the abstention doctrine, is specifically designed to prevent duplicate litigation, right? To discourage inefficiency and to maximize, therefore, the efficiency of the court system. Given how clogged our dockets tend to be, we don't want to have to relitigate issues in multiple courts redundantly, right? And that's what this is all about. Now, the Colorado River Doctrine should only be applied in exceptional circumstances, right? Meaning the abstention should only occur when the state and federal court proceedings are indeed parallel And if so, additional exceptional circumstances warranting abstention exist, right? So you need a lot to get to that abstention finding. And here's where we review. So proceedings, first of all, are parallel if they, quote unquote, involve the same parties and substantially identical claims, raising nearly identical allegations and issues. And that is called into question here, right? Cases are not parallel if they seek different remedies. And it's important to think about what's happening at the state court level versus the federal court level right now, right? So in our case, what we have with respect to the state court situation, Beavens is seeking money damages in state court, right? She's going after Golden Gate and then Dunyan and Curry with respect to the wrongful death action and the survival causes of action for Agnew. But Golden Gate is the plaintiff in federal court filing a petition to seek an injunction to force ADR. These are two different causes of action being filed by two different parties for two different purposes. They do involve the same general dispute, right? Because Golden Gate is trying to sidestep the state court action that Beavens is taking, but it's different parties requesting different things from different courts. And so you don't really have parallel proceedings here. So the difference in remedies precludes the Colorado River abstention. Thus, there is no reason to dismiss the case on this ground. And this brings us to the third and final reason or justification from Beavens that says, here's why the federal court system should stay out of this case. And that's the Anti-Injunction Act. So the Anti-Injunction Act is federal legislation that prohibits federal courts from issuing injunctions to stay state court proceedings. All right, so this is a prohibition as opposed to just allowing federal courts to stay away or to issue, to abstain at their own discretion. This is saying federal courts cannot issue injunctions to stop state court proceedings under specific circumstances. But there are three exceptions to the Anti-Injunction Act, right? These are the three circumstances under which that prohibition would not apply. When an injunction is expressly authorized by Congress, right, would be one. When an injunction is necessary in aid of the court's jurisdiction, would be two. And when an injunction is necessary to protect or effectuate the court's judgments, three, right? So the Federal Arbitration Act here does not expressly authorize federal courts to enjoin state court proceedings. But an injunction pending arbitration falls under the second exception, the court's jurisdiction, right, to the Anti-Injunction Act, because it is necessary to aid in the federal court here, the federal court's ability to compel arbitration under the FAA, right? So the court is finding that number two, as an exception to the Anti-Injunction Act, is satisfied here, right? Because it is necessary for the court to be able to exercise its jurisdiction to enforce that Arbitration Act pursuant to the FAA, that it stay the court order or stay the court proceeding taking place at the state court level, right? So the court does indeed have the authority to enjoin the state court, notwithstanding the Anti-Injunction Act, because one of the exceptions applies. Now, it hasn't yet found that staying that state court action is proper yet. It is simply deciding that it has the authority, the proper jurisdiction and authority to do so. That's what all of this has been about, because remember, all of these three analyses, the jurisdiction and the abstention and the Anti-Injunction Act claims, these are all arguments pursuant to Beavens' motion to dismiss, to throw this out in federal court, this meaning the Golden Gate claim, to try to get them to compel her into arbitration, right? And so what they're basically saying is, because we don't find any of those arguments to hold water, the motion to dismiss from Beavens is denied, right? So now that we don't have a motion to dismiss, this brings us back to the original cause of action, which is, again, from Golden Gate, saying we want you to compel Beavens to go to arbitration with her claims because she shouldn't be in state court in the first place. The arbitration clause in the contract that she signed, the agreement on behalf of Agnew, specifically says that all of this junk needs to go to arbitration. So she's violating her commitment, her signed commitment there, right, in breach of contract. So, standard, a motion to compel arbitration at the pleading stage should be granted without the benefit of discovery. So basically, this is a motion to compel in advance of the normal discovery, deliberation, mediation, and trial process. And the court is basically holding the standard of evidence here to say that that should be granted only if it is apparent based on the petition and its documents that the claims are subject to an enforceable arbitration clause, right? That based on everything in the evidence, that it's indisputable that there is an enforceable arbitration clause present, and that the party in question is beholden subject to that. A motion to compel should be denied, and discovery instead should commence if the complaint and its supporting documents are unclear regarding that agreement to arbitrate. All right, so if it is not clear-cut and unambiguous, then you would have a problem there. So if the ADR agreement is facially valid, right, which we'll talk about the extent to which it is, then the opposing party must show reliable evidence that it did not intend to be bound by the arbitration agreement, right? So this is saying that if the agreement Beavens signed is facially valid, meaning clear, unambiguous, not unconscionable, and we'll be analyzing all that in just a moment, then Beavens has the duty, the burden of showing that she did not intend to be bound by the agreement, and why that was a reasonable perspective on her part. Okay. In weighing the motion to compel at the pleading stage, the court must consider the petition and its exhibits, which include the state court complaint, the ADR agreement, and the durable power of attorney. Right. So this is what's submitted into evidence along with the pleadings, the sort of the initial disclosure, so to speak. So the court's inquiry here consists of two pieces. Number one is the agreement to arbitrate that we discussed previously. Is that valid in the first place? Right. Because if it's not, then we have a whole nother bag of problems to deal with. And this may fall flat. If it is, assuming it's valid, does the state court complaint from Beavens, right, the causes of action that she's bringing in state court, do they fall within the scope of the ADR agreement, right? Because you could argue that, yes, the arbitration agreement is valid, but if the court can find reasonably that her causes of action in state court are distinct, are outside the scope of that arbitration agreement, then they can coexist, right? You can have an arbitration clause that exists for certain claims and certain causes of action, but not others, which would allow her to bring those ones that are outside the scope. So as to the validity of the agreement itself, Beavens argued that the agreement was unconscionable. To determine unconscionability in a contract, Pennsylvania courts, and this is again applying state law because we're in diversity jurisdictions, so there's not a federal law precedent or common law to be applied here. We're applying Pennsylvania common law. So Pennsylvania would look to substantive unconscionability, which is to say whether the terms are so unreasonably or grossly favorable to one side or the other, and to which they disfavored a party, and that party does not assent to them. And then you have procedural unconscionability, which is a separate element, which is to say maybe the terms are fine, but the process by which an agreement is reached and the form of the agreement itself, including the use of quote unquote fine print or unclear or confusing verbiage or language, or important and material terms that are buried in what we would call fine print, or unemphasized language in the contract, all of that could lead to some finding of unconscionability that might undermine the integrity and the enforceability of that clause and of the agreement itself. So this is a sliding scale with respect to these two elements. In other words, the more substantively unfair a contract is, the less procedural unfairness has to be shown, and vice versa, right? So if you have a balance of both, that's fine, but you may have more of one than another, and that's okay too with respect to the claims, as long as you have enough of both in combination to satisfy the unconscionability standard. So in terms of substantive unconscionability, an arbitration agreement is substantively unconscionable if it limits the rights and remedies available to the opposing party in the arbitral forum, such as if it makes the forum prohibitively expensive for the weaker party, right? So if you forced someone into arbitration under something like an adhesion contract, which we'll talk about in a moment, but it makes it so costly financially and otherwise, so as to make it impracticable, right? And just to create a serious imbalance of power and leverage among the parties, then that could be considered unconscionable. Beavens argues here that JAMS Rule 26, again, JAMS is the organization that oversees the mediation and arbitration pursuant to her commitment, that Rule 26 requires each party to pay its prorated share of JAMS fees and expenses, and that is unconscionable. However, and again, this is the American rule, by the way, the American system is that you pay your own way regardless of whether you're in trial in a normal court system, or you're in arbitration or whatnot. That's the standard rule in America, as opposed to what is commonly referred to as the English rule, which is just the opposite. That is the rule that says the winner prevails, right? The victor has their fees for the case, their costs, their legal charges and costs paid for by the loser, right? So there's a lot of liability potentially hanging on a defeat in court under that English rule, because you could be saddled with all of the debt from that other side in terms of their charges and legal fees and costs. So the ADR agreement specifically limits Beavens' arbitration cost to $250, right, in this case, which it turns out incidentally approximates the fees to commence an action in court anyway. That's fairly commonly what it is to file a claim, regardless. Not certainly outside the scope. It's within an order of magnitude. Depending on which court you go to, it'll be a little more or a little less. But it's reasonable in scope, right, and comparable to a court proceeding. Now, Beavens paid $198 to initiate the lawsuit in Berks County anyway, right? So she's already in just $52 shy of that to make the court filing. So she can't really make an argument that the JAMS proceeding would be prohibitively expensive, because her total cost would be capped at $250. And then in addition to that, the court finds that Ms. Beavens paid $1,000 to perfect service by the sheriff on Dunyan and Curry in the state court, right? So she's in $198 to file the suit in Berks County, but then $1,007. So she's, more than almost 5 times what the maximum payout would have been under the arbitration clauses with JAMS. So there's really no argument to say that this is a financial hardship that would lead to an inference of unconscionability in the agreement. Beavens identified no other substantive issues with the ADR agreement that would speak to this issue. And thus, the ADR agreement is found not to be substantively unconscionable, right? But of course, the other question is it procedurally unconscionable? So let's take a look at that. So with respect to the form that was used, and this was a standard form contract, also known as an adhesion contract. You may have heard me use that term a moment ago. And basically all that means is that it is a take it or leave it kind of agreement in which there's really no real negotiation, right? It's not like we're going to sit down and haggle the terms. It's a standard form. You either sign it or you don't. It's kind of like, a great example is if you go and sign up for a cell phone subscription with, say, Verizon or AT&T, they're not going to sit down and go clause by clause with you on the standard form contract for cell phone subscribers and negotiate on the language and the jurisdiction and the dispute resolution details and the fees and everything. It is what it is, right? It is an adhesion contract. That is to say, it's take it or leave it. Either you sign it as it is in all of its terms in the entirety, or you don't, but there's no in between, right? And so that's what this was here. It was an adhesion contract. And in such cases, the court has to consider a number of factors, one of which is the extent of the take it or leave it nature of the form, right? In other words, is that coercive or unfair to the extent of being unconscionable? The relative bargaining positions of the parties, right? And again, there's always going to be some imbalance of power. It's very rare that powers across the table are perfectly balanced. For example, again, you take a look at your cell phone subscription example that I provided a moment ago. You have very little power, right, with which to leverage, contract terms to change with a company like Verizon, because, they have literally hundreds of thousands of customers. And if you don't like it, they'll find somebody else to sign the subscription. And so you have very little leverage to try to force your will. That the best you can do is to walk out, right? That's the really extent of your power there. So there is an imbalance of power, but the court is concerning itself with how much and where and why and the extent to which it matters, right? The degree of economic compulsions motivating the signing party, right? Was there any kind of economic coercion or hardship that would have forced the party to sign something that they otherwise would have been disinclined to sign, right? Absent such coercive forces. So for factor 1, the extent of the take it or leave it element, the court pointed out at the top of the first page of the agreement said that signing the agreement is not a condition of admission to the facility, right? This is important because, again, remember, Pamela signed this on behalf of Agnew at the time he was admitted to the facility. It was probably with other paperwork, I'm sure, that she had signed on Agnew's behalf. But it said specifically that she did not have to sign this in order for Agnew to be admitted to the facility. So there was no coercive element there that would have pressured her. Plus, the agreement allowed Beavens 30 days to change her mind, right? We talked about that previously. There was a 30-day back out or revocation clause in there that would have allowed her to get independent legal advice and perhaps change her mind if she wanted to, right? So all of that was present, which militates against the finding that the contract is unconscionable procedurally on that element, that the take it or leave it element was so unfair as to be coercive and unconscionable in that respect. So as we move forward to factor two, and again, with respect to factor two, Beavens argued that she did not share equal bargaining power. So again, this is the balance of power among the parties because she did not have the advice of counsel, right? She didn't have an attorney present. And so this made this unfair for her to have to sign this. Again, we've already acknowledged that she didn't have to sign it in the first place. However, the agreement also made clear that she understood she had the right to seek advice of counsel. It actually encouraged it, right, as we talked about at the very beginning. And if she wanted assistance of counsel, she could have consulted an attorney before signing the agreement if she wanted to, because she didn't have to sign it at that moment, or within the 30-day revocation period thereafter. She made no attempt to do either, right? So this is a really an argument that rings hollow in light of the circumstances. And Beavens also maintains that she was in a weaker position because she was busy dealing with an ailing parent being admitted to a nursing home, right? So she's saying, well, it's really not fair to hold me accountable for this because I'm dealing with my ailing father and I'm trying to get him into a nursing home. So I'm in a disenfranchised state at that point, right? With respect to, my ability to leverage and think clearly and negotiate and understand the capacity of what it is that I'm doing because I'm distracted by so many other things, right? So the court conceded, obviously, that any reasonable person can look at that and in decency and humanity understand, that that's a hardship of a position to be in, and that such a person may be vulnerable. But that doesn't mean that a contract that they sign under those conditions can never be enforced, right? That could lead to absurd and really problematic outcomes for society. It's kind of like a get out of jail free card for anything, right? So this specific ADR agreement includes a number of safeguards. It is short and contains no fine print. It can be easily understood by a person with no legal training. And in addition to advising the use of legal counsel and a 30-day reversal period, right? So again, it encouraged seeking legal counsel and allowed that 30-day opt-out. So regarding the third factor, with respect to the economic compulsion element, there was just no evidence of that, right? There was no evidence that Beavens was under any kind of economic coercion to sign or any economic or financial hardship. She wasn't receiving any kind of payment for this, that she was dependent upon, or that she was relying on, this signature for some kind of benefit, right? So on these grounds, given that none of the three factors really applied here, the court ruled that the contract was not unconscionable, not procedurally unconscionable, and not substantively unconscionable. So that was the final result of this. And so that brings us to the scope of the ADR agreement with respect to what we have here. So on the scope of the ADR agreement, the ADR agreement in this case was very broad, including all disputes relating to the stay of the facility, right? We talked about at the very beginning, we actually read the language from the agreement. We talked about negligence and gross negligence and the deviation or separation, departure from standards of medical care and medical rules, right? All of that was included. So the question is, does the scope of this agreement cover anything? Is anything in the state filing from Pamela Beavens that she filed against Golden Gate and the other defendants, is anything of that, does it fairly fall outside of the purview of the scope of the ADR agreement and the clause that was discussed previously? So the agreement obviously can only apply to Agnew Beavens, as the agreement was signed on his behalf. This is where we come back to this, and I mentioned this when we talked about this factually on slide 2 or 3, right? At the very beginning was that, remember, Pamela signed this agreement on Agnew Beavens' behalf with pursuant to her power of attorney over her father. So it was essentially him signing the agreement. It was just that he was doing it through a proxy, an agent who had the legal authority to do so for him. But Pamela was not signing it as Pamela Beavens. She was signing it as Agnew Beavens, as the agent, the legal agent of Agnew Beavens, right? And this is important because when we look at the different causes of action in state court, this is determinative, right, of the outcome. So the survival action counts are brought on behalf of Agnew, right? Again, we talked about survival causes of action pertain to the claims that Agnew could have been able to bring if he had survived the events in question, right? So they're his claims really, but they're brought by the estate, of course, because at this point he's passed away. So they include pain and suffering, loss of earning power, again, that economic loss, all of those claims that he could have brought himself, but now they fall to the estate, right? These would be to compensate Agnew, although they end up going to his descendants, right? Thus, the survival actions are subject to the arbitration clause because they all fall within the purview because he signed it, remember? And I don't mean he physically, literally signed it, but Pamela signed it on his behalf. And because she had power of attorney over her father, her signature for him was legally effective to bind him to that, which means that those causes of action related to the survival counts are within the scope of the arbitration clause, right? Because he was committed to that. Now, the wrongful death causes of action, on the other hand, are brought by relatives and not brought by Agnew himself, right? You can't bring wrongful death on yourself if you're dead, right? It is essentially the logical argument here. So whenever a wrongful death action is brought, it's brought by the descendants of the person who died, right? The people who are left behind, the survivors, right? And so these are actions brought by Pamela, right? The daughter. The wrongful death action is brought by her, not by her father. And she never agreed to the arbitration clause, right? Because again, she signed the paper, but she signed it as Agnew, right? With power of attorney for her father. She never signed it in her own personal individual capacity. And thus she's not subject to it because she never committed to it. So wrongful death actions are designed to compensate the relatives for the loss of services and the companionship of the deceased. Following on from that, the court observed that the Federal Arbitration Act was not intended to render arbitration agreements more enforceable than other contracts, right? It wasn't intended to give them some elevated status with respect to their commitments. A court can't compel parties to arbitrate absent an agreement between them to arbitrate that issue, right? If they don't have a valid signed agreement that's enforceable and meets all the terms of a valid enforceable contract, then the court can't say that in the absence of one that there should be some commitment otherwise. So since a wrongful death action does not belong to the decedent, it doesn't belong to the person who died, and is not derived from the decedent's rights, a decedent may not waive a wrongful death beneficiary's right to a jury trial, right? So in other words, Agnew didn't have the right to waive Pamela's right to wrongful death, and Pamela never committed. She never signed in her own capacity to the arbitration agreement. She signed for Agnew, right, with her power to do so pursuant to the power of attorney, but she herself never waived her rights. She never committed to that. And therefore, you have this wrongful death claim that is in fact outside the scope of the purview of the arbitration agreement. An arbitration agreement signed by the decedent or an authorized representative, which in this case it was, Pamela was his authorized representative, is not binding upon a non-signatory, right? Someone who did not sign the agreement for wrongful death, right? So it doesn't apply to Pamela because she never signed it. She never agreed to it. And the claim is hers to bring, right? The wrongful death claim is hers. Agnew Beavens could not alienate his daughter's rights to a wrongful death recovery, so his signature on the line had no effect on her claim. Therefore, Beavens' wrongful death claim is outside the scope of the ADR agreement, and the court cannot compel Beavens to arbitrate the wrongful death claim, right? So there's no way to find that wrongful death claim is within the scope of this arbitration agreement because Pamela Beavens was not a party thereto, right? That's the important piece here. Okay, consolidation under Pennsylvania RCP 213E. So this is an additional argument from the plaintiff side of the original state court action, in this case, the defendant's side of the petition to compel Pamela Beavens. So this is the argument that says, in the previous sections we discussed, the court had held that the survival action had to be arbitrated, those survival causes of action that pertain to Agnew himself, but the wrongful death action that belonged to Pamela does not need to be arbitrated. So the plaintiffs argued, meaning in this particular case, Beavens, that the two actions should be consolidated in state court under Pennsylvania law, which states, so Beavens is saying these should be all brought in the same action under state court because Pennsylvania has a statutory rule, and here's the rule itself. It's Rule 213E of the Rule of Civil Procedure, and it says, cause of action for the wrongful death of a decedent and a cause of action for the injuries of the decedent. So these are the survival injuries that we talked about, which survives his or her death, may be enforced in one action if the parties want to. But if independent actions are commenced, they shall be consolidated for trial, right? Not maybe, they shall be, right? So this this Pennsylvania Rule of Civil Procedure actually requires that any of those actions where they are separate, right? It's independent causes of action for the survival causes and the wrongful death, that they should be consolidated into the same trial. So the Pennsylvania rules applying here would require that these be handled all in state court, right, pursuant to the consolidation definition here under Rule 213. So the court analyzes this and finds a preemption of Rule 213 by the Federal Arbitration Act. So the FAA is a federal law favoring arbitration agreements. And I'm sure I need not tell you, as we've discussed at the very onset, we talked about the supremacy clause. I mentioned that in the first 30 seconds of this video with respect to the fact that, again, where there is a conflict, federal law controls, right? So there's an elevated level of authority with respect to federal law. It thus preempts state rules that are in conflict. And so in this case, state rule that requires a judicial forum for the resolution of claims which the contracting parties agreed to resolve by arbitration, right? Federal Arbitration Act, again, requiring that those claims be handled by arbitration and promoting that arbitration commitment would be undermined and would be subservient to a state rule if the state rule were to prevail that says, no, forget your arbitration agreement. That's irrelevant. We're going to combine these in a state court litigation action. Well, an arbitration agreement is revocable under grounds that any contract can be revoked, right? So that the contract can be rescinded, can be revoked or nullified. These grounds don't include a state's mere preference for procedures that are incompatible with arbitration agreements, right? So it's basically saying, look, the Pennsylvania Rules of Civil Procedure would obviously prefer that these claims be consolidated in state court for reasons of efficiency, but that is not a good enough reason to throw out the commitments that people voluntarily and freely of their own volition make to commit to arbitration or ADR of any kind, right? So state rules which interfere with the execution of a valid arbitration agreement are, as this court has found, the federal district court here, preempted by the FAA. Rule 213 is an expression of the Commonwealth's interest, meaning Commonwealth of Pennsylvania, in the streamlined resolution of survival and wrongful death claims, but this policy must give way to the Federal Arbitration Act's goal to ensure enforcement of agreements to arbitrate, right? So it must yield to the higher authority and the elevated level of importance given to the arbitration agreements that must be honored pursuant to the FAA's purpose, right? And then Rule 213 is an obstacle to the objectives of the FAA in this case, as it would require Golden Gate to litigate the estate's survival claim in court, elevating Pennsylvania's preferred procedures over a valid ADR agreement. They're saying this is not the order of priorities that should take place here. And so FAA controls, right, is basically the idea. So the claims must be bifurcated to accomplish the goals of the FAA, even if it will hurt the judicial efficiency of the Pennsylvania courts. So basically the federal court is saying, I don't really care about Pennsylvania judicial efficiency with respect to the dockets. Too bad, so sad. But yes, we're going to have to do this separately. I know that it would be nice to do it that way and consolidate, but that's not how it's going to happen here because the Federal Arbitration Act would take precedent over Pennsylvania Rules of Civil Procedure. So the plaintiff's argument in rebuttal to this, or as a counter argument to that, the plaintiff finds a case called the Taylor case, where the Pennsylvania Superior Court, right, this is one of the highest courts there in the land, held that Rule 213 is not preempted by the FAA. So apparently there was a specific reference to this exact issue that the Pennsylvania Superior Court had wrestled with and actually found the opposite holding, the ruling, as the federal district court is finding in this particular case. So according to that court, the Pennsylvania Superior Court, state rule is preempted only when it categorically prohibits the arbitration of specific claims, right? So again, there's a very specific exception there. Rule 213 is generally applicable to all contracts and is neutral as to arbitration, right? So it doesn't have a specific bend one way or the other on arbitration. It's not out to get arbitration or to thwart arbitration or undermine it, but it's neutral with respect to it, and therefore it's generally applicable to all cases, and it should therefore take precedence over the FAA. Again, according to the High Court of Pennsylvania in the state court system, right? So different court systems have differences of opinion here, clearly, right? So, however, the federal court here declined to follow the Taylor case, calling it an unnecessarily narrow view of controlling precedent, and opining further that the state court's opinion of the FAA is incorrect, right, with respect to the findings about it being subservient to Pennsylvania rules of civil procedure. That the part about the FAA not preempting Rule 213 was unnecessary to its ultimate holding, right, that it need not have even gone there in its opinion here. Interesting note, because that may or may not have been relevant whether or not they did opine, but insofar as they did, they put an opinion on record that's being attacked here, right? Also, it was distinguishable from our case, right? So the federal court here is making a point of delineation to say, well, the Taylor case was not like this case, and here's how. Unlike the ADR agreement in the Beavens case that we've been talking about, the Taylor arbitration agreement stated that it was governed by Pennsylvania's Uniform Arbitration Act, and the case here chose the FAA as the applicable law, right? So the specific reference in the arbitration agreement that was signed by Beavens, between Beavens and Golden Gate, and to be handled by JAMS, cited FAA as the authority for applicable arbitration law, right? So it calls the FAA into authority here by virtue of its specific reference, whereas the Taylor case hearkened to the Pennsylvania Uniform Arbitration Act and relied on that as the authority, right? Which would speak to, right, the level of weight given to the FAA and the delineation there. In any case, the court observed that it is not bound by the Pennsylvania Superior Court's interpretation of the FAA, right, which is sort of funny, but it's basically, courts playing a little territorial with things, and in this case, the federal district court saying, we're not subject to Pennsylvania Superior Court's interpretation of anything. I don't have to honor their rules or findings or opinions. It's this. I'm so glad that they, decided this way or ruled this way, but it doesn't matter to the federal court system because we are not subservient to them, right? So an interesting point noted here. So the court ruled that the FAA preempts the application of Rule 213 in this case. Basically, they found that, that 213 is in fact subservient to or subordinate to the FAA rules. So now we address finally the issue of the mandatory stay with respect to the state court proceedings. So what happens here? Party to a valid arbitration agreement is entitled to a stay of state court proceedings pending arbitration under the FAA, right? So again, you have this Golden Gate Living Center pursuing that with the court here, but the issue here, as the court notes, is as a point of sort of healthy balance and deference to the state court. The federal court says that it can deny a stay of the wrongful death action since the plaintiffs are not bound by the arbitration agreement, right? So again, the survival causes of action are forced or compelled into arbitration here, but it can deny a stay of the wrongful death action since the plaintiffs are not bound by the arbitration agreement. So in other words, it can't force the state court to stop that clause because that cause of action is not covered within the scope of the original arbitration agreement. The court conceded that in some cases it may be advisable to stay litigation among the non-arbitrating parties pending the outcome of the arbitration. The court reasoned here that it is in no position to tell the state court judge how to manage his or her docket, right? So again, this is a point of deference here. So they're basically saying that, look, it might be wise for the state court judge to say, let us put the wrongful death action that remains in state court on hold while the arbitration proceedings are pending with JAMS to find the outcome. And the judge may have the authority to do that, to stay that proceeding until the arbitration is finalized, because that decision and the findings there too may be relevant, right, to the outcome of the wrongful death action. But the federal court here is saying that we are not in a position to tell the state court judge that he or she must do that, right? So in this case, that is ultimately at the discretion of the state court judge. And so therefore the court denied the motion to stay on the wrongful death count, right? So they're basically telling Golden Gate, we are not going to tell the state court that they must stop that action at any point. If they want to allow Beavens to move ahead with it immediately, then they can, because that's not really any of our business. So concluding this particular action, the court, again, denied the plaintiff's motion to dismiss the federal petition to compel for the three reasons we discussed: jurisdiction, abstention, and the Anti-Injunction Act. Granted the defendant's motion to compel mediation, and if that doesn't work, arbitration through jams with regard to the survival action counts, right? Those that originally belonged to Agnew had he survived the incident. Denied the defendant's motion to compel ADR with regard to the wrongful death action, because again, the wrongful death cause of action belongs to Pamela, and Pamela was not a signatory to the arbitration agreement, right? And then granted the motion to stay the state court proceeding with regard to the survival action counts. So with respect to the state court, it stopped those proceedings in state court, but also denied the motion to stay the state court proceeding with regard to the wrongful death action count, right? Because again, that moves forward within the state court at the discretion of the state court judge, right? So lots of interesting back and forth with this case, lots of interesting and intricate analysis on a lot of these points, from jurisdiction to unconscionability to even contract elements. So this case is loaded with a lot of legal precedent, both legislative and common law issues. But hopefully it was helpful in understanding how arbitration agreements are enforced and what happens when they are challenged at both state and federal court levels. Thank you so much for listening, and we'll see you next time for another great video. Take care.